So, on the 19th of June this year, the long awaited Data Use and Access Act received Royal Assent. It's deemed to be a refinement of existing data protection legislation. However, there still are a few new elements and some changes organisations should consider when reviewing their data protection practices. In this podcast, we will be discussing changes implemented by the Data Use and Access Act, in which we will refer to as the Act, and what organisations should do to ensure they remain compliant and by way of best practices. My name is Melanie Pimenta. I'm an associate in the data protection team at Clark's Legal, and this is Harry Berryman, who is a solicitor with me in the data protection team.
Thanks, Melanie. So, yes, let's start with data subject access requests, commonly known as DSARs. DSARs are the mechanism by which individuals can request their personal data and even ask for it to be corrected or deleted, along with other rights. Most commonly, we see individuals requesting copies of their personal data, which can be time-consuming for the organisations involved.
Yes, definitely. So, generally, we have previously relied on guidance from the ICO, which will now be renamed the Information Commission under this Act, in regard to how DSARs should be responded to. So, the Act has now introduced two helpful clarifications. Firstly, it provides a statutory basis for pausing the clock while awaiting further information from the requester. Secondly, it confirms that searches need only be reasonable and proportionate, which sets out boundaries for organisations to find the requested data.
Yes, it is good to have this clarified in the law. It's also interesting that the recent ruling in Ashley and HMRC has also highlighted the risks of taking too narrow an approach to searches for personal data, and it may be that wider searches are required on a case-by-case basis.
Yes, and in addition to this, the Act has clarified that responses to requests must be made within 1 month, which can be extended by a further 2 months for complex requests, provided this is confirmed within the original 1 month timeline.
Yes, and the Act also clarifies that the timeline for responding does not start until the controller receives any clarification information they require, or alternatively, when the fee, if any, charged in connection with the request is paid. For example, a controller may reasonably require further clarification where it processes a large amount of information concerning that data subject.
Yes, it's currently unclear how this will be applied in practice. I mean, for example, will this now be a general right to stop the clock and ask for information where there's a large amount of data processed? Or is the Information Commission going to say this should only be used, if generally required?
Yeah, I agree. This will be one to keep an eye on when this is increasingly applied in practice. So let's move on to another new element of the Act, which links to DSARs. The Act outlines a new complaints procedure for addressing complaints from data subjects. This says that the data subject can make a complaint to the controller and the controller must enable complaints to be made. For example, by providing a complaints form. They must acknowledge receipt of a complaint within 30 days and must, without undue delay, take appropriate steps to respond to the complaint and inform the complainant of the outcome.
Yes, and it also states that appropriate steps include informing the complainant about progress of the complaint is needed too. So it will be the case of ensuring that once a complaint comes in, it's acknowledged within the correct time frame and is worked on accordingly with updates to the complainant to ensure that they are informed of the latest position.
Indeed. And interestingly, the Secretary of State can make regulations requiring controllers to notify the Information Commission of the number of complaints they have received. It just shows that a risk of not dealing with complaints correctly could lead to reputational damage.
Yeah, I agree. And I think the attention behind this change is to ensure that controllers deal with complaints in the first instance with the Information Commission, dealing with matters which are then escalated. So we would suggest ensuring that you have an appropriate complaints policy in place to ensure you comply with this element of the Act.
Exactly. The impression you get both from the legislation and our work with clients is that the Commission doesn't quite have the resources to promptly deal with every DSAR-related complaint it receives. They seem to be hoping that the controllers will more proactively comply with their obligations here, rather than need the Commission to step in after a complaint is made. So, let's move on to a new lawful basis for processing. This will be called Recognised Legitimate Interests. Currently, there are 6 lawful bases for processing, where legitimate interest is one of them, But what does the new definition of recognised legitimate interests actually entail?
Well, this is going to relate to particular situations where a legitimate interest assessment is not required. So, in essence, it will apply to disclosures to a person carrying out a public interest task, safeguarding national security, protecting public security, or defence purposes, amongst other specific purposes. It should also be noted that the Secretary of State can add to the list, so I would suggest keeping an eye on any more additions to this list, as at the moment they seem quite specific.
Yes, and it would be worth considering if any data protection policies and privacy notices need to be updated to account for this additional lawful basis of processing.
Yeah, I agree. So, on the same topic, legitimate interests, the Act has set out a non exhaustive list of examples of processing activities that can constitute a legitimate interest of the controller, in which these will be subject to the usual legitimate interest assessments.
Yes, these are to include processing that is necessary for the purposes of direct marketing, intragroup transmission of data, and processing that is necessary for the purposes of ensuring the security of network and information systems.
Yeah, it seems like a very specific change, but it's still worth checking policies and privacy notices if these legitimate interests are being relied upon to make this clear.
Thanks. So let's turn now to the purpose limitation principle. This principle has required organizations to ensure that further processing is always compatible with the original purpose. But what does compatible really mean in this context?
So the Act has introduced a new Article 8A, which sets out clear circumstances where further processing will be deemed compatible with the original purpose. So these include situations where the data subject gives fresh consent, where processing is for research or archiving, where it serves the public interest or relates to crime prevention or safeguarding.
Okay, so this clarity is significant as it offers organizations a stronger legal foundation when reusing data, particularly where there is a public benefit.
That's true. And I would say that organizations should still be mindful of the transparency obligations they're subject to and document decisions carefully to demonstrate compliance with this.
That's true. So, as we have seen, AI has been increasingly used in organizations and is really kicking off at a fast rate, quicker than really can be regulated. But where the UK GDPR has said that individuals have the right to not be subject to solely automated decisions that have legal or similarly significant effects with only limited exceptions, the new Act proposes to replace this with a more flexible regime.
Yes, the Act will allow for broader use of ADM in low risk scenarios, provided that appropriate safeguards are in place. So, this does signify the UK trying to strike a balance of creating a framework which is AI friendly, whilst obviously upholding the fundamental rights too.
Indeed, and with the quick uptake of AI, particularly where organizations may use AI for recruitment, credit assessments, or customer profiling, this change brings new opportunities, but also suggests that those organizations will need to be transparent on this.
Yes, I agree. And I think it will very likely be the case that organizations will need to invest in transparent decision making systems and obviously ensuring robust governments with humans overseeing decisions made by ADM to manage the risks.
Exactly. So, we're just going to move our attention to international transfers before considering a couple of final changes. International transfers has been a tricky area for organizations to navigate, particularly since Brexit and the abolition of the Privacy Shield. There has also been the consideration of adequacy decisions.
Yes, adequacy decisions have required a high degree of equivalence between the UK's data protection team and that of the recipient country. So the Act is moving towards a risk based approach by introducing a new data protection test, whereby the Secretary of State will assess whether a third country's data protection is not materially lower than UK standards.
Yes, so there will be a shift in considering whether differences in legal frameworks actually present meaningful risks to individuals' data rights.
Yeah, and I anticipate for businesses this could simplify lower risk international transfers and encourage cross border trade.
Yes, and we would still recommend that organizations with a high quantity of international transfers undertake a risk assessment, particularly where countries are not deemed to have adequate safeguards.
Yeah, and in a similar vein, on special categories of data, which includes medical or health data, the Secretary of State will have the ability to add categories to this list too.
Yes, and while we're not aware of any specific changes to the list, it is going to be worth keeping an eye on any updates to this to consider if your privacy notice or policies will need to be updated.
Yeah, definitely. So, a final point to mention is in relation to PECA. So, this is the Privacy and Electronic Communications Regulations. This is one of the most striking changes in which the alignment of penalties under PECA is within those of the UK GDPR. So, this is raising the maximum fine from 500,000 to 17.5 million, or 4% of global turnover, whichever is the highest. So this is obviously a substantial increase, which exemplifies the government's intent to enforce compliance with marketing rules, particularly around direct marketing.
Yes, absolutely. As before, we would recommend that organizations review their practices and ensure robust consent mechanisms are in place. Where the Information Commission is already deploying automated scanning technology to detect cookie breaches, enforcement action is likely to become more proactive, in which organizations should be alive to the potential financial and reputational repercussions.
Yeah, I agree. Thank you, Harry. So we can help you by reviewing your privacy notices and data protection policies, as well as drafting a complaints policy to ensure that they are compliant with the new Act. We can also advise on any specific data sharing agreements where international transfers or personal data are involved.
Yes, and if you have any queries or require our support, please don't hesitate to contact us via Clark Siegel's website.
Thank you. That's great. So, this brings us to the end of our podcast, and thank you for listening.